Hi, everyone. Carl Steinbeck here on a Friday night. Want to talk about the Karen Reed case coming up next week. We should have the jury finally selected and start with opening statements and on to their first witness for the prosecution. There was an issue tonight. I had to reschedule the coverage I wanted to have on the medical discussion for John O'Keefe's injuries, the Boston police officer that was found murdered in a front yard in Canton, Massachusetts. This is a retrial for Karen Reed, his girlfriend, who is being accused of using her vehicle to back up and strike John and leaving him there in a snowstorm of sorts to leave him for dead where he's supposedly found the next morning. But there was a mistrial for the first trial. Now we're on to the second trial. That's, as I say, starting next week. So what I decided to do is just go ahead and switch it up and talk about the defensive strategies and tactics that I think would be helpful for the defense next week, what I anticipate being done, and some concerns I have for what it's like dealing with a court like this. This is as bad as you can ever see it. When you got a runaway prosecutor and a judge that doesn't have anything but contempt and no appreciation in her rulings anyway for the Constitution and longstanding traditions of what defense are entitled to get a fair trial. This is anything but a fair trial that I'm seeing for Karen Reed in the first trial and here in the second trial as well. It's already starting out, and it's going to be way worse because the current prosecutor, last name Brennan, is much worse to deal with than the previous one. Lally was an inexperienced prosecutor, and Brennan, he's been in crim law for many years, and he knows all the tricks to pull. He knows all the stunts to pull, and he knows how to basically be on check now for whatever he wants to do, suppress the defense, try to steamroll them, and basically prevent them from having anything of a constitutionally required defense. So we've seen that through his motions to keep out an expert witness for law enforcement. He's trying to keep out these ARCA witnesses. He says he's not, but he's looking for ways to try to gut them as well. So I think the judge is the way she set it up for voir dire before they testify, the day before they testify, that it's nothing but a ambush and waiting for someone like this prosecutor try to accuse them of doing some wrongdoing or some ridiculous story like they're biased. These ARCA witnesses are not biased at all. They're true professionals. They run a professional business, and they're hired by the FBI. And shame on you, absolutely shame on you, Hank Brennan, for being that low of a prosecutor that you try to keep that out. And shame on the judge. That's absolutely disgusting. It's sickening. It's un-American. It's unconstitutional. And you guys ought to be ashamed of yourselves, okay? That's all I got to say about it. It's so infuriating and angry. And I don't care. I don't care if you have a defendant that is guilty. When you resort to those kind of stunts and play and hide the ball from the jury, you know what you're doing is wrong, okay? You all know it's wrong, but you're doing it anyway because you're that much wanting to win a case. And in the end, you will lose, and this will come back on you through any appellate decisions if it comes to that, because you're banking on all this suppression of the truth is gonna help get your conviction. Well, guess what? Even if it does, you're gonna lose big time. You're gonna be known as the kind of people that played dirty on this case and didn't give her a fair trial. So you cherry pick the law, you cherry pick all this rationale, you put a spin on stuff, and it's just the worst I've ever seen. So this is a rogue system, and so what I'm here to do tonight is tell you all how these defense counsel they need to get their game together. They better prepare for warfare in the courtroom. All right, so a lot of times I look at trial attorneys and I look at how they act, how they conduct themselves, how prepared they are, how well they know the law, how aggressive they can be in the courtroom. And I always think that athletes, especially athletes that play contact sports, have an advantage in the courtroom. I always look at the game of football as a game of aggression, violence, strategies, tactics. And when I blew out my knee, couldn't play college football anymore, I wound up becoming a trial attorney. And I basically look at the courtroom as a mental game of football. And football's a smash mouth sport, and you better be able to go in there and use your mind and use your wit and use your argumentative skills and knowledge of the law and facts. And you got to just crush your opponent. You got to have the warrior mentality in your mind, and you don't take no for an answer. You got to have your willpower, your sheer willpower, which is you're not gonna let things get out of hand. You're not gonna let this judge just ramrod these ridiculous rulings. You got to make a record. You got to make it aggressive, and you got to make it assertive. And no matter how many sidebar motions you got to have with the court, I would actually call out the judge on her history of bias in her rulings, her attitude, her demeanor, the way she makes all these comments. I have a long laundry list of stuff, and tell the judge that, she is conveying to the jury that this defense team is not to be trusted, and they need to call her out on that. Okay, she hates them already. So what are you going to do? Have her hate you worse? You need to do it as defense lawyers. You need to stand up to the bad rulings. That's what I would be doing if this was in Texas here, and I faced a judge like this, and I had a client like Karen Reed. So they're calling for war against Karen Reed and her defense team. So guess what? You better look at it as a game of war. Okay, I'm not talking about a war of violence. Obviously, I'm talking about a battle of wits, a battle of minds, a battle of words. You better come in there super sharp, super prepped, and you better be able to slug it out and call it out. And I think you need to speak to the courts of appeal, because this judge isn't going to listen to you. Okay, so if the judge is trying to shut you down, you basically say you're making an argument to the Court of Appeals. All right, so that's what you need to do, and you need to let these characters. I could say a whole lot worse, and I just got to try to not use some of these choice words. I'm trying to keep this channel clean, so I don't want to have any kind of saying of words that I'll regret. But needless to say, I think you guys get the feeling how angry I am about seeing stuff like this going on, and it's just the worst I've ever seen. This gets my blood boiling when I see this going on, and I don't think you could ever see a case worse than this. Okay, so with that being said, I think I'm going to go through a couple different things. If you guys have questions as I'm going through this, I will stop and we can discuss these points. So like I say, I would start out in the beginning before you even have opening statements, after the jury selection's over with, and I guarantee you, this prosecutor is doing everything he can to get rid of the people that he thinks would be most sympathetic to Karen Reed. So he's going to cherry pick and try to set up people to have him challenged. And so I'm hopeful that the defense counsel is countering a lot of what he's trying to do to kick off their certain people. I think normally you're looking at a situation where prosecutors, they try to keep off folks that are of a lower socioeconomic status, racial minorities. Those are kind of things that prosecutors try to kick off. They may try to kick off upper middle class or middle class females, especially white females, if they're like because they could relate to Karen. But on the flip side of that, women can be toughest on women. So I don't know if they're necessarily going to do that, but males could be more sympathetic to Karen and what she's going through and some of her medical ailments, and men tend to have sort of a protective role for females anyway. So, but I think that whatever kind of tactics have you been using for jury selection, it looks like we're close to a 50-50 makeup of males and females. Of course, we don't know their ages or anything like that. And I think that there's a lot of games being played. I just haven't seen what's going on, and we haven't heard sidebars. So eventually we'll see a record of this and what kind of tactics are being used. But suffice it to say, I just don't trust anything that the judge or this prosecution is doing for jury selection. And for the judge to be able to pick the foreman, I'd be raising objections for that as well. That's something I've never heard of before. That let the jurors go back and decide who the foreman is. Because the judge knows who she wants best to help control the jurors, to steer them in the direction she wants. That's why she picked a former cop to be the foreman. So and it worked pretty good. And the other thing that I have to do is get these jury instructions cleaned up. And if she just says, "Well, that's the way we do it here in Massachusetts," I would give the instructions you think need to be given, and fight tooth and nail for that, and build a record of that at least. So you're not going to get redress probably in even these Massachusetts court. It's a very draconian system there. So I would say the best you can do is build a record, and you better build it well, frequently and often, because you're going to, this is a complete railroad job. Okay. The, the other thing I would do is, try to humanize Karen as much as possible. Notice the prosecution witnesses. Prosecutors always usually tell the witnesses that they call to call the defendant. Defendant, don't call them by their name, so they're not going to say Ms. Reed or Karen. And so, as a defense counsel, I'd be calling Karen as much as you can, not Ms. Reed, but calling her, humanize her the most by calling her by her first name or saying Karen Reed occasionally. I think that it's also important that these jurors know that this defense team is pro bono. I think their expenses are probably being paid by the funds being contributed, but in terms of salary, they're all been working months for free, is my understanding. If that's true, then I'd go ahead and say that. I mean, this Robert Alessi, he came on after the first trial, and my understanding is he's been doing it free from the get go, and so maybe he's just being able to have some lodging provided for and some meals, but that's not your salary. And he works at a huge global firm, DLA Piper, out of New York City. So for a guy to come up there and join in on this case and take it on like that, I mean, they really believe in their client. And that's really great to see, because a lot of attorneys, they don't really, what I see, they don't really care so much about the wins and losses. They care about just how much money can they collect from their client. So it's good to see these guys are all stand up. I think they have much better credibility in front of the jury than anything the prosecution has with this Hank Brennan. And I think having a local guy there, Yannetti, is a good thing as well. I think having a guy from California, Alan Jackson, can come with risks. He's a good advocate, and but I think sometimes having somebody that doesn't have their kind of northeastern kind of personality, that may not connect as well with the jury. I've heard that he's going to be doing the opening statements, and if that's the case, I think what I was wondering is, we haven't heard who they're going to do for closing arguments, but I'm thinking Alessi might be the best for closing arguments. I think of the three attorneys, he comes across as a guy that has the most conviction, and for this kind of case where you got so much of things that were botched, I think he has the most credibility, the most conviction. The way he speaks with authority. He speaks with sort of like a professor or a senator type. And you only have an hour, so if he can talk slow at times, but I think if he speeds it up and hits all the points and hits reasonable doubt, um, um, I would say probably almost every minute or two, the whole time he's arguing. But I'll definitely be arguing for more time as well. They need to have like at least uh, a 90-minute or 2-hour session to argue. I think also I predict that the cross examination will go a lot quicker in trial 2. Because in trial 1, if you think about most of the questioning was done by Alan Jackson, and he didn't know the answers to so many different questions because he never had a deposition for these witnesses, and there wasn't a good police report to go off of. So he's just asking so many different questions he doesn't know the answers to. But now he knows the answers. It's sort of like you look at trial 1 as a deposition. You got the witnesses locked down in a story, and you got them, previous testimonies given in grand jury proceedings. So there's you should really have more of a tight shot group, and I would say you want to do less open-ended questioning. You really need to hone in on just going for zinger type of things to discredit them. So really the cross-examination should not be several hours. It should be pretty much less than a half hour, I would say. But each individual attorney can have different reasons for doing that. But definitely a little longer than an hour, I would say. I would also point out that in the initial jury selection process, if you noticed, Judge Canoni when they do the statement of the case, there's a script she reads. That's something that Brennan had submitted to the court to have be read to the jury to tell them about what the prosecution's theory of the case is. And they start off by saying allegedly there was a phone call to 911, and they start off the timeline like around what is it, 6 something in the morning, instead of reverting back to when John was struck with the car. In fact, they don't mention any of the timeline of when John was struck with the car except the last sentence. The last sentence says hours earlier, he was struck by Karen Reed's vehicle. So they don't even say the timeline. So remember, in a previous video I talked about how the timeline moved in the trial one. It went from 12:45 to then around in their closing. Then they sort of like fudged it into say 12:30. So they don't want to get too pinned down on their timeline, and they're hoping the jury doesn't focus too much on the timeline. So even in this opening statement of the case, they did not say what time Karen Reed's vehicle struck him. And so that is a critical thing. And I would bring that back and hit him on it frequently and often, that they don't even have their timeline straight to this day. They keep on moving it around, or they try to avoid it because they don't know what time it fits, because there's different digital evidence that exonerates Karen Reed, and they don't want to have to talk about that. So they only want to talk about the spin effect of how different timelines link up with the testimony of folks like Jen McCabe, who said it must have been around 12:45 that she left. And as we know, Karen Reed was already back to John O'Keefe's residence and on the Wi-Fi at 12:36. So you got to bring up all those inconsistencies, even that started out in the first opening minutes of jury selection. For each day, they brought in a new pool. I would say they also need to, as far as this media stuff, Brendan is trying to have all these different statements Karen made to the media. I don't like the fact there's different statements she made different times, or like they say, we don't know who did it, or yes, we do know who did it. I don't like those inconsistencies. That's why I'm not a big fan of any client ever going out to the media and talking that way. It's because the prosecutor can try to use that at trial, but I think the defense needs to be aware of the fact that if the prosecution tries to bring these in, you can object and say they're not an admission of any type. And statements of a defendant or any other witness comes in if it's contrary to their claim or interest, if they make a statement that's contrary. So you can bring in a hearsay statement, an out-of-court statement off the truth of matter asserted. And one of the exceptions is admission by a party opponent. So the party opponent for the prosecution is Karen. So whatever Karen says to somebody else, whether it's a journalist or a friend or whoever, all that kind of stuff could come in, but it's supposed to be an admission. So I think the defense, it behooves them to make sure that these things are really an admission, and if they're not admission, then they shouldn't be coming in. So they should be ready to object to that. I think also this whole thing with the ARCA, I would hope that they get totally squared away and they comply with the reciprocal discovery, and they don't give Brennan an opening that there's some kind of disconnect on the communication when they talked, or what was shared, or what questions were asked ahead of time. That, hey, we're going to ask you about this in court. You don't want to have another goat rodeo with the judge accusing either the attorneys or ARCA witnesses or both of doing something improper, to not comply with the reciprocal discovery. So they better have it nailed down tight. Also, you have Proctor, the issue with Proctor, and they need to be very aggressive on him as well as these other witnesses, way more aggressive than they were in trial one. And because they have more knowledge of what their story is, they can really hone in and pin them down, and really make these witnesses know that they know that they're onto them, and make them really realize that they're going to pin them down on what they said, and they're not going to let them off with just one or two slick answers. So the slick answers, the contradictions, they really need to call them out on it and really be aggressive about it. None of these witnesses that are in the house says that John came into the house. So they need to be able to bring more and more applied pressure and more exposure on their contradictions, their motives. And I know that Jackson did that sort of with Jen McCabe, talking about, that's her sister. They're like family. All of them are like family there. Their families are synced together. So, in other words, they basically would do whatever it takes to protect the family, and so they need to do more and more detailed crossing of these many inconsistencies, which I won't go over in detail now, but it is possible to rattle these witnesses. I think they think their safety in number, that all these folks said there wasn't anybody who came in the house, and because the number of witnesses, I'll challenge the judge on the fact that the number of witnesses is immaterial to this being proven or not. Okay, it's up to the jury to decide. The judge can't decide, well, nobody admitted to John being in the house, so therefore he was not in the house. I mean, that's the way she writes it in these rulings. Like, that is the honest to God truth. I mean, I had a case one time where a guy went to his ex-wife's family's gathering where she had invited him, and then they jumped him and beat him up, and they accused him of starting it and fighting them. So that's a case that I was able to win by just one at a time, gunning them down, discrediting them. So none of them admitted to them starting it by questioning them and showing their inconsistencies and their motives and how it was ultimately a setup. That's the kind of way you can make some inroads for that. So I was able to get an acquittal on that kind of guy. And so this is sort of the same kind of thing. This is an ambush. These people are have a lot of issues that they're trying to duck and run from. So the defense really needs to exploit that. The judge is also reaching back to the first trial a lot. So I would say they need to have the transcripts ready to also cross-examine them on inconsistencies, because their stories may change again, and bring out the fact that stories and timeline of the prosecution keeps changing. It's a moving target. So, all right, I'm going to look at some questions here now. Karen Trog, you're saying the defense needs a visual timeline to present to the jury. Yes, they need that. Um, Leslie, this is not my wife Leslie, but a different Leslie. Defense needs to hammer reasonable doubts constantly and nail the 245 timeline. Nail them as being that's pin them to that exactly. Kate's agreeing they changed the timeline. Risa Biller saying the same thing. They botched it. Yeah, Sherry D saying Lally even said his closing. Karen said I hit him 4 times. Yeah, she didn't. It wasn't 4, right? It was 3. Janae, you're saying Alessi would be on fire with the expert witnesses. I think Kennedy would be awesome to close. I do think, though, I'm just telling you from my trial experience, I think I have not seen him argue in front of a jury, but I think that Alessi, what I'm looking for in a case like this is conviction, speaking with conviction, and I think Alessi has, and also the likability. I think Alessi has the ability to connect best with the jurors and have that conviction, because conviction and believability, what you're arguing. Um, I think Yannetti has a conviction as well, but I think every word that Alessi says, he has such clarity and conviction. He's super intelligent, and he's also more local. I think having a guy from California won't connect as well, even though he's very good in his points he can make. I I just I just think it would be best if Alessi did it. Thanks, Mr. Monk's understudy. Stay pause. You're asking, have I ever experienced a judge like this? Yes, not this bad, but I had a judge one time that would coach the prosecution and say, I haven't, he would say, overruled on an objection on those grounds, but I haven't heard the grounds of such and such yet as the base for rejection. So then he's basically telling the prosecutor, if you object it this way, then I'll go ahead and let your objection be sustained. So I had him doing that multiple times in a trial, and I just let it go because I was thinking about having a sidebar and challenge the judge on his bias, but I was routinely practicing in front of this judge. I'm like going, I still think I can win it without the judge doing this. So it was better off not to have him be ticked off at me for years on end and hold it against me and all my other clients. So, but in this case, if you have attorneys that are never going to practice in front of her again, I mean, I don't think Alessi will. I don't think Jackson will. Yeah, Yannetti has to, but so anyway, have one of the other attorneys challenge her if need be. Lee Moon, you're saying 50 prosecutors, they had to hire an external for 250K. Well, it's going to be a lot more than 250K. I'd say it's probably going to be like 600,000. Kerry Mache, you're saying recommend how to argue regarding the SUV hitting John going backwards 24 miles an hour and the family moved one of their vehicles at like 3 a.m. Yeah, well, we don't know when that 24 miles an hour was driven that fast in reverse, right? That's based on key switch entries. It's not a time stamp on when car was reversed. So it could very easily the car being backed in reverse. We don't know how many times it was turned off and on with the key ignition, or if it's a push button ignition. We don't know how many times it was pushed on and off. So, and yeah, why was that Ford Edge moved after 3:15, 3:30 in the morning? Right by his body. So his body was right there, and the Ford Edge got moved right up there. I mean, that alone is right there is reasonable doubt for Karen Reed. So there's so many things that are reasonable that you should have doubts on if you're on the jury. Sherry D, you're saying I think AJ needs to dumb it down with the words he uses when he questions said witnesses. Yeah, I would just not use big words either. And I know he called Trooper Paul an expert when he said, according to according to your expertise, would you say such and such was sort of how it went? And I'm like, I would never admit that he's an expert. No way. Challenges expertise, so-called expertise, every step of the way. Okay, idea delights. You're saying defense already tried recusing the judge, denied. They already went to court of appeals, denied. FBI's Washington prosecution does not have any evidence. Okay, well, you need to keep arguing that the judge is being biased and showing favoritism. So just because she ruled at one time and she's still acting biased, you still need to call the judge out on that. Mr. Monk's understudy, you're saying unless his brain makes sense to everything. He's just a credible guy. He's super smart. And sometimes you have guys that are so academic, they don't relate to a jury. And I've always said that the more academic thinking somebody is, the worse of a trial attorney they are. They can't think quick on their feet. They use big words. And when I see an attorney using big words, I know that they're not that successful as a trial attorney because you don't want to use big words as a trial attorney. It turns off many of the folks on the jury. Oh, thanks, Eminem. That's nice of you. It's yeah, I hope you all are seeing the same thing I'm seeing. I mean, I'm just calling it like it is. Any person in America seeing the way this judge and prosecutor acting should be very concerned with where our justice system is at. Risa Biller, you're saying I think the jury will hate Hank. I don't know if they're going to hate him per se, but I think a guy like him, I think a guy like him, he's sort of like the guy. He's like an Eddie Haskell kind of guy. He's the kind of guy that rats you out and then goes and does the same thing he's accusing you of doing, kind of thing. I just don't trust him. RG 1561 or 561, you're saying, didn't we hear the judge has voir dire and ask pre-selected questions given attorneys control? There's a long laundry list of questions. That's how they screen them. And the judge, yeah, from what I understand, allows very few questions by either side. She wants to control it. Sandy, you're saying I'm concerned about her decision to go for 20 jurors now means she'll kick off anyone she thinks is pro Karen like the last time. I don't know how many they're going to settle with. I think at least 21 because trying to keep 12 people around for this long, if it goes up to 2 months, is going to be hard to do. And you don't want to have to do a mistrial because you lose 12 jurors. So I'd rather do overkill than cut it short like that. All right, I'm not going to cover the ARCA thing about who is paying what and where. I think that's we're gonna find more details about that at the their voir dire. So think about it. That's how dirty and corrupt this system is. So you're going to have Brennan arguing that they're biased, and he's also hiding behind the fact that the FBI and U.S. Attorney's Office hired him. Is that not a farce? Is that not this kind of sleazy, underhanded tactics that you should never expect from a prosecutor who's supposed to uphold justice? So you're going to be arguing that they're biased and trying to just degrade them and smear them as being some kind of clowns that are just in it for the money. And you're hiding the fact that these guys were neutral, hired experts for the federal government to investigate basically corruption within the the Canton area, Norfolk area. So that is how bad this gets. And then you have a judge that's just going to rubber stamp this kind of shady business. That's how sick and disgusting and low this case gets. And these guys are supposed to represent justice. Sam, you're asking, do I think the judge has a specific strategy for increasing number of jurors from 16 to 18? Well, if she also gets to pick the foreman, I think the more jurors that there are, the more she can pick ones she thinks are favorable to the prosecution. So that is a concern of her strategy. And I don't know if the defense can do anything to keep her from picking the foreperson. So, but yeah, it's definitely gives rise to shady politics if you allow a judge to pick the foreman or foreperson. All right, don't let's be professional here. We don't need to call. I can't get rid of that. All right, we don't need to call anybody a witch. Thanks, loud mouse. It looks like I can't see. It's not showing me. There's something going on with StreamYard here. Okay, now I'm scrolling back down. I'm on, we're at 8:46, current time local here. LS, aka Chester's mom. Carl, will you go to the trial? Thank you for all you do. I don't know if I'm going to go to the trial. Not sure yet. Leslie and I talked about it, but I hear it's really hard to get in there. So I would hate to go all the way up there and then just be having to watch it on YouTube. Anna, you're saying the corruption and bias is in your face. They don't seem to care how transparent with the bias it is. Sherry D, you're saying Grano testified at 12:36 a.m. Then Lally changed timeline. Uh, Kim, you're saying Alessi should close. His presentation is more lively, organized, passionate. He holds the attention of the jury, which they need coming down the home stretch. His words will stick with the jury better. That's what I'm saying. His ability to have his words resonate with the jury. He comes across super smart, but he doesn't come across as highfalutin or elitist. He doesn't talk down at people. He's very conscientious and a respectable gentleman is the way he comes across. And I think Yannetti does as well. And I think Jackson comes across as likable, but I'm telling you, having more local kind of guys in an argument where you really need to kind of connect with a jury, I think would benefit Karen the most. Gary Rubner is asking, is there a chance that the first jury was coerced by the foreman? He likely made others consider Jackson as an outsider. That could have very easily happened. I know for a fact, I talked to a juror one time. It wasn't my case, but it was another case. And the this was in this was in this is a DUI case, and this is a defense attorney that was hired from a smaller town like 100 miles away, and there was two guys in the jury. It was initially vote was uh 10 to 2 not guilty, and these two that voted for guilt, they were able to flip all these other 10 around to voting guilty when it was like a complete joke of a case. They had no direct evidence of impairment or intoxication. There was no breathalyzer. She walked straight. I even heard from the judge that he thought it was a female being on trial for DUI. And these two guys got the whole jury all worked up in a frenzy because they said that this guy's from out of town. The only reason she's got this guy from out of town is because she knows she's guilty and she's going down. So she's spending all this money to get an out of town lawyer. Why else would she do this? And you know what this guy didn't bring up? He didn't bring up the fact that she doesn't have any prior convictions. And the only reason he did that is because they know she's got priors, and they convinced the guys that on the others on the jury that this was a felony DUI woman, and she's got prior convictions for DUI, and she needs to go to prison. And if you let off somebody, you know that she's going to kill somebody. I mean, just all this hype they spun up this jury, and they got it. They got them all to vote 12-0 to convict, and so that's how you can have people be strong armed. So I think something like this cop doing something like that, not allowing him to ask questions, not asking the judge for clarification on, hey, can't we decide at least 1 in 3 and not guilty instead of this having this count 2 string us up and basically how the whole thing be hijacked as a mistrial. So that's why I think the judge is trying to hold out to do is get somebody that's going to be the best foreperson. That's one reason that you could get more folks involved. Um, so that's a downside to having more of those involved. But like I say, for the sake of not having to have a mistrial just because you ran out of jurors. Look at that. We've already had some folks seated, and then they get removed. The next day they got to be removed for some reason. So that's already happened a couple times. Sam, you're saying in Jen's testimony trial one, she often did more than answer AJ's question by including her narrative. What can he do to stop her from ad-libbing? Yeah, she ad-libbed a lot, but you need to call out the witness on that. Just be direct, be confrontational, call them out on all their inconsistencies, call them out on their motives. When were these witnesses directly accused of being part of this? They're making them out to be a third-party culprit, which I don't think you need a third-party culprit defense. I think you just need a reasonable doubt that something else happened, somebody else in the house. The evidence is very clear digitally that Karen was not there when John was beaten up, beaten to a pulp, beaten to death, and just hammer home on the reasonable doubt. But yeah, you definitely got to have more control over her and call her out on her different agendas. Also, think about it the way she talks about Jen being upset when she goes, Jen, like she's like, how annoying was her calling my name like that? Well, she actually loves John, and that's why she was upset about John. And so all you see her doing is like really mocking Karen for being upset about John not coming home that night. So it's one of the clues. One of the clues that that what she's saying is not legit. She doesn't really love John. Look at the way she didn't help him out at the scene there. When they were hauling him away, she wasn't looking at him what he was up to, and she didn't seem upset. Look at how she called the 911. She didn't seem upset. She says she basically called him a dude laying on the side of the road. Some guy, actually, I think his exact word, some guy laying aside, some guy, and this is the guy she loves, and he's a Boston police officer, and she knows it, and she doesn't even tell the 911 operator to get quicker response. Extremely, extremely suspicious behavior, and they need to call her out on that. Thrilled, you're saying, can the defense fully name third-party culprits to the jury? The reason I wouldn't do that if this was my case in Texas is that when you do third-party culprit, here you have a number of them, not just one culprit. The judge is limiting it to two, but then it's almost like you're raising it where the prosecution can rebut it. And then if they rebut it, then basically your whole defense centers on whether these two guys did it. It's like a matter of who done it of these three, and the prosecution, you don't really have enough on the other two. So by default, it must be Karen. And that's sort of like what this jury was doing by saying, well, Karen was the one that we know dropped him off, and we really don't know what happened after that. And nobody believed he went in the house. It's like, well, what about all these lies and inconsistencies that were brought out? So that's why I think they need to not necessarily bring out third party culprit, because it's going to be tough to show to get anybody to admit that John came into the house. You're going to have to do that through circumstantial evidence and inferences and the motives of these people. Motives is key, and it's something that I rely on over and over again to win cases, whether the prosecution or defense attorney on a case, because motive is so much a predictor of people's behavior and why they're acting the way they do in a criminal case. And so that's what I think they need to really focus on is the motives of these folks and their inconsistencies. So the ways you can attack the witness is on cross examination, and they should just have this like ready to gun them down. Is like um, prior inconsistent statements, and they got number priors now, and they got number inconsistency. We've seen some of that on Jen McCabe and the others like Higgins and Chris Albert, and a lot of what they say just doesn't make any sense. They're acting not the way law enforcement should be acting. So you got prior inconsistent statements, motive, bias. You also have the any prior convictions, which we're not going to have here for the police officers and for the McCabe's. There's not going to be any prior convictions for that. But so you have all these areas of fertile grounds for cross examination. So just go through it and be very aggressive and pin them down. Don't let them weasel out of different things, especially when you got prior statements for them. One of the things I try to do, especially when I'm cross-examining somebody, is they know I know they're lying, and the way I'm questioning them, I'm letting them sense that they're not fooling me at all. And the way I zero in on them, and I'm not looking at a script, they know I know what they're saying is not true, and it makes them more rattled, and you're going to get more mileage out of it that way. All right, Linda Mon, you just asked about motives. I think I sort of covered that already. But Sixth Amendment right to confront, and also for motives, they better have their case law lined up. They better be having cases like I mentioned before, Davis v. Alaska, and other cases that talk about the right to cross-examine somebody on their motives, to fabricate, and have that Supreme Court case law, U.S. Supreme Court case law, that gives them that right to do that, and have that already written in the record, and try to get the judge to allow you to do it. But this judge, the more she's going to try to help the prosecution, the less of a chance you get that in. But at least build a record, continue to build a record, and again, call her out on her bias and prejudice against the defense. Dirty Bev, you're saying every time they try to be aggressive, the judge sustains everything. Well, then have sidebars, have motions calling her out on her bias, her rulings that are not consistent with case law, Supreme Court case law, and have that case law ready to go. I don't know I've never seen another attorney that came to court with case law prepared to argue how to cross-examine somebody. So you better do it, especially a case like this. Most lawyers just thinking, well, if I lose a motion or a objection, I'm just going to let it go on to the next question. But me, I would say you better come there with case law and be arguing and build a record. You got to build a record against this judge, and don't be afraid to take the time to do it. Levy 33, you're saying I totally agree. Karen Reed should not have done so many interviews. Yeah, especially if she's saying stuff like this doesn't make any sense, not doing her any favors. And she had enough support. She doesn't need to get into specifics. So just not a fan of that. That was probably more I would say AJ's doing than the other attorneys. I think the other attorneys be more like traditional lawyers that say, don't let your client talk to anybody outside the time you're going to call them as a witness in their own trial. Kara Feeble saying more Americans need to be familiar with jury nullification. Jury nullification is basically the jury, even if they think the defendant's guilty of some or all charges, they're so disgusted the way the prosecution has behaved or the witnesses behaved that they basically say, no, I'm not going to sign up to this. Case in point, when back when I was a special assistant U.S. attorney in Alabama and a chief of criminal law there, that was the time that O.J. Simpson was on trial, and I had asked an assistant U.S. attorney what he thought of if he was on the case that let's just say Ron Goldman's dad, I forget his first name, if he would have come back and murdered O.J. Simpson, would he have? If he was on the jury, would he have found him guilty? He said no. And so that would be a jury nullification, where basically you're thinking, you know what, the guy had it coming, he deserved it, and so I'm not going to find somebody guilty of that. It's sort of the same kind of thing if you have like a child molester. If um, somebody finds out that somebody was molesting their child and they go ahead and kill them, a lot of people would have a hard time giving them punishment if it was definitely proven. Obviously, you don't want to something that's uh, not easily proven. But if it's easily proven and you know something happened bad that way, or somebody killed a family member of yours, if there's vigilante justice and stuff like that, a lot of people, especially like states like Texas, you could see a lot of that. Not so much probably in Massachusetts, though. Risa Bill, you're saying they give him all the ARCA stuff. He's just complaining to make it seem like there's more there. There isn't. He asked for it 4 times now. He has everything. He's just afraid of their testimony. Yeah, he's just doing something to get in some kind of accusation that he can try to smear them with, and the judge totally wants that to happen, where they can try to catch them in some kind of disconnect on what they disclose, or maybe an email that they forgot to include, or something like that. So they better have this thing ironclad, locked down, because the judge and the prosecutor do not want ARCA witnesses, because that's their best one of their best defenses. Matilda, you're asking what, if anything, can they tell the jury about Proctor's firing? Well, that's going to come out, and so they're just going to try to minimize it, say he's not as involved in the case. That basically all the other evidence was there, and if you notice in the first trial, Alley was always asking whenever Proctor was asked, whenever they asking about the sequence of events for these other law enforcement, they're asking always, was Proctor there with anybody else? And they're always trying to establish that Proctor had somebody else around him to prevent him from doing anything shady. So they know he was a hot mess, complete disaster as a witness, completely corrupt as an investigator. Karen Trog, you're saying should the defense spend less time on Proctor's text and more time on how he botched the investigation? I would do both. I think the text, um, I would really rake him over the coals on them texts. My voice would be very loud. It'd be a booming voice in the courtroom, and basically really be shaming him, and making him say those words, and making him say more specifically about his those kind of words like that. When's the last time you used those words? And try to make it where more of like, especially the women on the jury, are disgusted by the way he talked about Karen. So I would do things to make it look like that's the way he generally talks about women, not just Karen. Dusty Blue, though, you bring up a point, though. Could she even try to block them from sharing the fact he's fired? Yeah, who knows? This judge is, I wouldn't be surprised, but that's a constitutionally required thing. Jody, thank you. I cannot open your super sticker. Madeline Wags, you're saying it. The judge said the video of Higgins on the phone wasn't necessarily proof he's on the phone. He could have been walking with the phone, just held up to his ear. Absurd. Kate, you're saying if Karen was guilty, she would not have been hysterical when finding John and be the only one to do mouth to mouth with his mouth full of blood. Yeah, I mean, she didn't act like she wanted him dead at all. There's nothing there to indicate it. I do think that Karen was too drunk to remember what happened, and that allowed her to be manipulated by the narrative from Jen. All right, let's see. You have Tanya Dorling is asking, do other lawyers pull other lawyers up for being dodgy? I know in my work, respect from peers is invaluable. Here you got, it's different though. You got two attorneys that are never going to practice in front of that courtroom again, other than this trial. Yannetti is there, but it's, I wouldn't want to be Yannetti having to practice in front of this judge ever again. That's got to be hard for him to deal with in the future. It's not going to be fun. But I think the thing he has going for him is no matter how this trial turns out, I think the reputation of that town and the justice system is forever tarnished and damaged in a serious way. Mr. Monk's understudy, can you give specific examples of how the defense can be more aggressive effectively? Well, part of it is your the conviction that you speak with, your aggressiveness, your willingness to call sidebars, your willingness to keep engaging with the judge. If she denies it, you ask for more. You basically just say, Your Honor, I need to be heard on this. I need to build an appellate record, and you keep going on, and you just don't give up. The way you aggressively attack witnesses, you just got to everything you do. It's something that is calculated to be aggressive, and the jurors pick up on that. If you're very aggressive and you're confident in what you're doing, jurors pick up on that. They look to see who really believes in their cause. And think about it, Brendan is going to be putting so much spin on so many different facts, trying to get the jury confused, that it's it's going to be to defense advantage in this case. So basically, you got Brennan acting like a defense attorney and the defense counsel are acting like prosecutors, but they can't take all this pushing around by sitting back on their heels and just letting Brennan get all these shots in and the judge siding with him. So they need to keep building a record. They got to keep building aggressive, um, and they got to be aggressive on these witnesses. So it's like I say, you got to be wire brushing these witnesses, make them squirmy based on how tough you're crossing in them. Long Light 827, you got to keep hammering home on the timelines, present a timeline. She says you can't do a timeline, bring a timeline to the courtroom, say, Your Honor, this is what we need. We absolutely need this. You're hamstringing us. Just keep hammering away at this and just don't just take, do a one line request. The judge says denied, and then you leave it at that. Carrie B is saying that actually happened to me. My drunk neighbors jumped my sister, and the cop said, Well, all six in their party said they didn't. So, like what? Of course they all lied. What do you expect? Yeah, it's so obvious. People that are all at a party are not going to admit to something if there's a fight that went on from some outsider that's not as close to all of them. Of course they're not going to admit it. They're all going to circle their wagons and point the finger at the outsider. JW, you're saying, how can they say with straight face that John's arm was caused by taillight fragments? The scratches are straight patterns. Taillight pieces do not align in midair and scratch in the same direction. Exactly. That's totally true. And that's why the this is really common sense kind of stuff. You don't need an expert to be able to understand that. But apparently in Massachusetts, that can be too complex for someone on the jury to understand, because some are wanting to go with involuntary manslaughter. But I think that's mostly because of that cop on the jury there. I see our North Carolina retired troopers on the line here. Good to see you, sir. The judge doesn't want any kind of chart showing a timeline because she knows that can hurt, but hurt the prosecution. but they need to keep pushing away at it. Gary Rudner, you're saying it's most likely intentionally planned and botched to keep too many people from facing any real charges. I mean, that's what it looks like. Swampy, you're saying, what about how they sprinkle that red plastic everywhere? If a car did not go up into that yard, isn't it just absolute absurd proof of their corruption? Well, just the way they went out there multiple times and supposedly finding evidence each different time they went out there over a matter of days. It's really astounding, and the way it wasn't recorded properly in the police report. Thrill is asking, have I seen a pro hoc visa not allowed? I've not seen it. It's really rare that people get out of state attorneys on criminal stuff. All right. If you have questions, Reddit emojis are easiest way for me to see them. Sam, you're asking if defense calls the judge out, can she hold them in contempt? Well, they need to call. I think as long as they're building a record and staying for a record, then what you going to do? That's what their advocacy is. If the judges one side in their rulings and it's totally working against them, I would say that what you can do, hold them in contempt and then kick them off the case or something and stick them in jail while the trial proceeds. I don't see that happening. You do it in a respectful but forceful way to build a record. Karen Trog, you're saying AJ's closing was amazing but too high level. The jury needs to hear specifically how the prosecutor did not prove their case, and there's reason to believe that others were involved. I'll be the judge says 236 over and over again equals reasonable doubt. Yeah, that's such a strong. That's her alibi. I've said in that in another live stream. That's her alibi. I guess Trooper Carolina, you got hit with a lot of hail, but no damage. That's good. They're in North Carolina. Swampy, you're saying the Ford Edge was shielding the killers as they staged the scene in the yard behind it. No other reason or explanation for it. I'd really hit home on that Ford Edge as well. Karma Dharma, you're saying John's temp was at 6 a.m. 80 degrees. Reverse engineer that, and John was brought outside at about 3:45 a.m. I don't think it's that quite linear on the time sequence. If you look up body temperature and sub-zero weathers, I think it decreases like 2 to 3 degrees an hour, which seems really slow, super slow. So I don't trust that timeline you're presenting there, and I'd have to do more research on it. Barbara Logico, you're saying unless he commands exactness, I detect jurors will have an affinity, gravitate to him being 550K concise. He's articulate, manner, bring out riveting points. Dear DB, asking why any thoughts why last year I think Jen McCabe was being honest. Yeah, that's just I think that's just from one guy, so I wouldn't believe that that he can speak for everybody. Leslie's saying the Ford H blocked the cop's ring camera from across the street. That might be it. Okay, thanks, Loud Mouse. Let's see. You're ask Higgins why he was texting Karen, why Karen romantically until the day John died. Ask her why Alexis was told he can't do them, being the only heated Sally port for Mansfield. Bet that's a lie. I bet that's a lie too. That's a good point. Thank you. Yeah, so the texting suddenly stops. His texting towards Karen. Madeline Wagner saying, I don't know all the words Leslie uses. He's brilliant, love him, but he cannot use those kind of big words in front of a jury. He can do that in front of a judge. He can impress a judge that way, but you do not impress a jury. It can turn them off. So he needs to tone the big word usage down. Baby Fish, thank you. You're saying, how can the defense hammer the witnesses when the judge affirms both objections and even solicit them? Like I say, you got to keep hammering away, going sidebars, calling the judge out. Have the case law, ample case law, supporting your argument of why this is proper cross examination. So if she still cuts you off, still be aggressive, have a loud tone, have a tone that conveys that this witness is lying, and you're gonna call them out on their inconsistencies and their motives. Yeah, that's what I think of Eddie Haskell. Thank you, Madeline Wags. Appreciate you. JW, you're saying, what if new attorney Victoria opened with, I was actually a juror for her first trial and we acquitted her on 2 or 3 charges? Yeah, that would be something. But the jury's not supposed to know about why it's a mistrial and what the vote was, or how they were deliberating, and they never actually came up with any kind of signed verdict form describing that. But yeah, that'd be nice to see, wouldn't it? It just would never happen. Lawyer, you're asking, do I suspect the judge's peers are upset at her handling of this case? There's a whole place corrupt. Don't know. Don't know. I would say they got to be scratching their heads, wondering how can this judge looks that bad. The rest of the judges in Massachusetts, can they really be that biased and come across that bad? I can't imagine it. Shelley Bean 13, you're asking, do I think the defense will call Julie Nagel back to the stand? Well, I think the prosecution will be calling her. If not, they would call her, yes. Because the timeline there from the 8:20 or 12:21 to 12:29:30ish, that window's critical, and she helps him out with that. It's personal for the judge. I agree. This is personal. This is not professionally. She knows she's giving bad rulings. There's no way she's that clueless. It's never a mannequin. You're saying they promote her, so they're all part of one big club. Those judges. Well, actually, it was the governor of Massachusetts that appointed her. So she's got some political pull to be appointed a judge by a governor. What interaction would she have with the governor? She knows people that knows someone there that's tied with the governor. So that's what it took. PG, you're saying that Lexus has an anti-accident feature in reverse driving. That's what we're hearing. So that's a good point. In fact, I should call up the Lexus dealership tomorrow and find that out. So, note to self, I need to call up and find out about that for a 2022 Lexus GX 570. Barbara, you're asking again, why can't lawyers command the judge recuse herself? Well, you can ask for it. You can't force a judge off like that. They could do a writ of mandamus to have the higher court order the judge to be removed or else fight it on appeal. Davey Salmon, you're saying, I think the other judges in Massachusetts are probably mad at the damage she's doing to the justice system. The world is watching. Yeah, they deserve it. They deserve it for having this kind of an absolute clown show of a courtroom. Sam, you're saying you wonder if after the beatdown in the house, as we suspect, maybe John was trying to walk home and fell down after 83 feet by the flagpole. I know the end result is the same. That's one of the scenarios I would say the defense could argue. They could argue scenarios without having to directly point fingers at folks. But if they want to do that third party culprit, they're going to have to get more in direct accusatory mode, I would say. Otherwise, they're not going to be taken seriously on their third party culprit. If they don't directly attack and confront Higgins and Albert for you guys are the ones that did it and you did this and that, and basically walk them down what they did exactly to beat up and kill John O'Keefe, then I don't think you really want that kind of instruction. And I think it's a much higher, like I say, it's a much harder burden to go than just to show all their discrepancies, show their motives, show their absolutely strange behavior. They're acting so guilty, right? They're never going to admit that John came into the house. So just show how they're acting as if he came into the house. Dusty Blue saying the judge is the gatekeeper for Morrissey. That's what it looks like. Alcohol and audacity, you're saying, I remember when you said you don't care about this case. It seems like I do now. No, I do care to see this kind of corrupt thing going on. I think I might, maybe what you're alluding to is maybe in the beginning when I said I don't have a dog in the fight. I don't know whether Karen did it or not. I'm just talking about what they had proven to the case. I didn't follow it enough to make that determination whether I thought she's guilty or not. And so that's what you're probably alluding to. And so, but now that I see this thing going on, and the more you look at it, the more it's got this extreme shock factor. And you just the way they now had this Hank Brennan as a prosecutor, it's really getting ugly as it can ever be. Parker's Planet said you need hard evidence unless it's Officer John O'Keefe's case. If you don't have good evidence, you got to rig the system. You got to keep out experts. You got to deny truth coming out to the jury, like the ARCA being hired by the feds, all that kind of stuff. Cross examinations denied, objections overruled, and on and on and on it goes. And that's the way you have a rigged system, and how innocent people can be prosecuted successfully. Boston Babe is saying, do I think maybe the attorney should call her Miss Reed instead of the defendant, or is that a court thing? Well, the prosecution is allowed to call the defendant, and they also will tell, as I said earlier tonight, they'll instruct all their witnesses that they call to call Karen defendant. Sometimes they may call her Miss Reed, but pretty much they're always going to call her defendant. And that's pretty much universal around America. The prosecution does that. And then, but her own attorney should be calling her Karen and Karen Reed the whole time. They should never say, I hate it when an attorney say my client. I remember AJ saying that a bunch of times. I cannot stand it when I hear a lawyer saying my client. So I don't think that humanized your client at all. That is, to me, it just sort of like makes me think that, well, that's your client, so you're willing to argue anything that your client wants you to argue. It's not really legitimate based on facts. So just call them, make them human. Just call them by their name, first name mostly. Great day, Mom. You're saying Silver Draft Supercomputing. They're the company that manufacture the computer systems for Toyota, Lexus, Subaru. Silver Draft. Okay, I'll write that down. Thanks for sharing your knowledge on that. Ellen Reaver, stand reasonable doubt, not third party. That's what I would do. Harry's mom, you're saying truth revealed. Channel says Higgins could have hit him first in the driveway by the garage. Any of these kind of things are possibilities. The defense could argue all these scenarios. The prosecution cannot dispel them because their theory is a complete nonsensical, not physically possible based on what we've seen for the injuries, and also the way they describe a body flying 30 feet just by hitting an arm. That's not physically possible. Brian Higgins says a tall, dark man was in the house. Defense should ask others in the house, who was it? Yeah, and if they don't know who it was, they never saw him. Well, that could be the same thing with John O'Keefe. Maybe John O'Keefe was in the house. Like, does a people with in the house and different locations of the house, are they really going to be zeroed in on who was in the house and who wasn't, and who's coming and going, and all that kind of stuff? I just don't think people are like such hawks wanting to monitor who's coming and going like Jan McCabe was for John O'Keefe that night. Eliza Krogan, you're saying, I hope this jury doesn't fall for someone saying defense deflection on all their witnesses. Juror on the first trial said one juror kept saying that during deliberation. It was probably the foreman's, my guess. Al Dente, I agree with you. It's no longer about John O'Keefe or Karen Reed. It's more about protecting the Commonwealth. Corn Pope, you're saying, how would you cross Jen McCabe? Evasiveness asking for documents. I'm not going to do a mock type of cross on her. I don't want to give any chance, if they're looking at this, any chance for her to be prepared for this. But I would have a much more aggressive, in your face kind of cross examination. Yeah. And keep in mind, Carrie Roberts called Karen the defendant more than one time. PG, I agree that Jen asked for documents is to buy her time to invent an answer. I do stuff like well, you got your lawyer right there. You're telling me your lawyer hasn't prepared with you to testify in a murder case where the deceased is somebody you love? Just start hammering away at stuff like that. Call her out on her garbage answers. Install tactics. Have sort of a mocking tone to what she's saying when it sounds ludicrous. Your tone should reveal through your questioning that it's just completely laughable, her answers, and expose a motive that way. DS on YouTube, yes, that's what I'm saying. If you have to have affidavits from a number of people that say this is what I'm observing during the trial, and it's very much apparent that this judge has resentment, and bias, and prejudice towards the defendant. That's what I'm talking about. Twirling her glasses, doing all that kind of stuff. Those sighs and all that kind of stuff, the way she just talks in a monotone voice and just acts like these, rights and jury instructions just don't matter. Conscience scene 413. Higgins did plow John's body after the beating. I mean, that's something that one of the scenarios they could argue. Great Dean Mom says, my friend is the founder of Silver Draft. They'll be, well, thank you very much. Sean Thompson, Always McCalber saw nothing on the lawn. Yeah, I mean, you could even just the way you ask the questions, I don't want to get too much of role playing here. Do a mock cross examination, but you could really make these guys embarrassed. The way your voice inflection, your tone of voice, and don't take the witnesses too serious. When a witness is lying so much, don't take them too serious. Just act like you're onto them. Nobody's believing it. Sort of act like you don't believe it. By the way you're questioning, you're just sort of the way I'm coming across right now. I don't believe it. And then you get aggressive with it, and you sort of make a mockery out of them in your questioning. So that'd be harder for the judge to shut down on something like that. Little Miss Red Velvet. I don't think I'm going to cover the live. I think I'll just do a nightly recap. And I think I'm gonna be so mad. I don't know if I could calm down enough to make it through the whole day with seeing this absolute disaster of a so-called trial, this kangaroo court going on. I'll be the judge saying on cross. Green testified there were deleted locations on Karen's phone made April 2022. Whoever made those deletions tampered with evidence. Her phone was seized on one on 12922. Isn't this huge info? Yeah, that's something they could make a big deal about. And so there's so many little rabbit trails they could go down on impeaching these folks. They really need to have it locked and loaded, ready to go. No, no, Nanette is saying, is this just cops closing ranks, willing to jail the wrong person versus seek justice? That's what it looks like. Okay, I'm catching up to y'all here. Little misread. You're saying Jen McCabe started the "Did I hit him?" quote. She also said there was a man passed out. Well, she changed it to much worse than "Did I hit him?" to saying "I hit him." I hit him multiple times. So yeah, and then I've already made the point about a guy. She called him a guy pass out in the snow instead of saying this is Officer John O'Keefe laying in the snow. He might be dead. Hurry, hurry. He's a Boston police officer. Hurry, send help at ASAP. Send an ambulance right away. No, she didn't talk like that, like she loved him at all. And I'd call her out on that. She's got to be hammered on that big time in cross examination. Al Dente is asking why Brian Albert was at the police department was seeing the witnesses in an adjacent room. That was at the McCabe's. He was at the McCabe's the next morning wanting to listen in. That's what my memory serves me correctly on. To correct me if I'm wrong, but yeah, they wanted to control the script. They wanted to know who was not going to follow their tightly scripted storyline, and that's what it looks like. That's how to be arguing if I was defense counsel, anyway. JW, can the defense reference BA and BH as the culprits since they literally named them in the court filings? Well, the judge is not. She's like on the fence with that. She said conditionally they're approved now, but she's got to see how it comes out at trial. So they may not be able to use a third party culprit defense, which I'm like I say, I don't think it's a big deal. I wouldn't unless you're going to really go after them and accuse them of that, and you think you got the ability to make some kind of big home runs in your crossing points. I don't think that's necessary. Annie Lavelle is saying, "Can I do a mock test after the trial? Show us how you do it." It's for me. I'm not good at acting at all. I'm a terrible actor, and so trying to do mock stuff like mock trials, I'd be terrible at mock trials because if it's not real, I can't fake it unless it's really real, it's really happening. Um, I guess I've done some of that in trial advocacy courses where I'm trying to teach younger folks stuff. But if it's not really legitimate and really happening real time, because it's really like a mindset you get into, and you just sort of like, I zero in on the witness, and I know like their story better than they do, and I'm going to uh, ask so many follow up questions, and they're going to see I'm not looking off any script, and that really intimidates them, and they're going to know that they're not going to weasel out of their lies as they thought they might, because I'm going to be crushing them. Rusty Bubbler, you're saying they were all drunk. How do any of them remember anything? Yeah, I'd zero in on that too. Higgins says, when he got to the house, he had maybe 2 drink. He says, I don't know. And then, oh, maybe 2. It's like, oh yeah, the common answer 2. Yeah, right. All these officers driving drunk. Harry's mom is saying they don't have to prove you went into the house. Could have been beaten up at the garage or behind the house in the side yard. I mean, is there any number of things and scenarios that could have happened? And the defense doesn't have any burden to prove that. The prosecution has to prove exactly what happened, and they can't. Russian Aloha is saying this court has never cared about John O'Keefe. I would have to concur with that. It's a shame, yes. Colors flight, you're saying isn't less than normally a higher court attorney like appeals. I think he does a lot of stuff, not just I think criminal law is not his normal main specialty. So I think he's more of a corporate type commercial lawyer. Kate, was Jen ever asked who was with you when you said Karen asked you to Google about hypothermia, why hobbling to die in the cold? Yeah, they haven't pinned down who exactly was where and what and how when that happened. And I submit that it didn't happen, right? Sam saying I'd be more emotional than Jen if I even saw an injured animal on the side of the road. Yeah, she was like a little squirrel got ran over or something. Dusty Blue is saying Jen gotta be hammered on the timeline with her phone calls. John O'Keefe looking out the window time frame saying, how could you see her car at 1240 when Karen Reed was connected to John O'Keefe's Wi-Fi at 1236? Yeah, the timeline was not pinned down on her very, very well or good enough. Great happens saying, would you ask also about Jen's attachment language, like during the 901 call when she says they went out drinking last night instead of we went out? That's a good point right there. I agree. Lindsay Tyler, they should all be making a huge big deal about the fact that Brian Elbert ended up with a sling and an arm and shoulder injury all of a sudden the next day. And maybe that's why he didn't come out of the house. I've heard something about the sling. I don't know where I heard that, so I don't know if that's accurate or not. Does anybody have any details on that? Al Dente, you're saying no, he went to the police department. Brian and Mindy sat in an adjacent room and listened to certain testimony from witnesses at the police. That is super suspicious. Okay. I got that. My memory serves me wrong. I was thinking that was at like the McCabe's or something. So, okay. Thanks for clarifying that. Cheryl with an S is saying, it's been said Brian Albert's been muscle for Morrissey for years. Thanks, Great Dane Mom. We need to have hope for Karen. We need to believe that justice can happen. We need to pray for justice to happen because there's got to be hope. You can't have this much of a disgraced sham trial and think a jury's going to be that tricked into not seeing it for what it really is, despite them trying to hide the ball on so many important critical facts that would guarantee an acquittal across the board. All right, so let's see. Sam, you're asking what would happen to Karen if she went in the house. Well, I think she was there. I think the defense will argue she was going to be intercepted by Jen. If that was the case, that's why Jen was so adamant looking out the front door. That's why it looks suspicious that way. Kim H, why didn't she Google it instead of asking for a paramedic standing there? Yeah. All right, moving ahead here. I'll be the judge is saying Jen's phone data showed her moving during the time she said she was sitting in a police cruiser when Karen asked her to Google how long. Wouldn't you pin it down on this? Prove she is lying. Those kind of things are huge discrepancies to bring out. Absolutely. Where are the other witnesses to that if that really happened? Rachel Johnson is saying, even if a person confesses, don't they still have to do an investigation to make sure they're not making a false confession? Well, just to even prove it in court, you need more than just a confession. There has to be some kind of corroboration that has indicia of credibility and truthfulness in the confession. So you are correct on that. Rosemary Gallagher, you're saying many folks in Canton saw him with a sling, saying he was injured on the job, no sling at the bars. He went into hiding. Oh, Rosemary Gallagher is saying she did see him with a blue sling on. Wow. Well, that should come out then. Rainy Day Girl, I agree. Reasonable doubt is there so many different ways. Josie Miller, does the defense have any recourse so the judge limits them to an hour for closing arguments? I would say that unless they do a writ ahead of time, this judge is going to limit them, and they're just going to be stuck with it. Okay, Mr. Monk's understand. Just get the facts straight. Brian Albert, Northern McCabe's were ever questioned at the police station. Carl, you were correct. It was at the McCabe's house. That's what I remember. So, yeah, I don't think a single witness was brought down to the station at all that I recall. Okay, let's see. We have but El Dente's coming back saying no. Brian said he went to the PD, listened to two witnesses sitting in adjacent room. Well, send me that then. My email's on my YouTube channel here at the top. Okay, I'm just going to do, we're at hour 42. I'm going to do two more questions and then we'll call it a night. I'll maybe back Sunday night. Kira Feeble saying there's lots of photos of Albert in a sling. PJ saying it sickens me that the judge never refers to John as Officer John O'Keefe. Dusty Blue, defense should ask Proctor, isn't it police protocol to bring all witnesses to the Canton police station and have video documentation? Why did you not? They need to go into all those kind of details about things that were botched in this lack of investigation. Carrie Bead is asking, do I think there's a connection with the charges upgraded so the judge would get the case? No, I don't think that was the reason. I think it was to strong arm her into pleading guilty to a lesser charge if they would offer that. And so therefore, it does happen a lot. Either charges are upgraded or downgraded based on what the district attorney's office wants to do. But for this to go to a second degree murder charge is just a complete intimidation game. There's no facts to justify it that could be convincing of any jury beyond a reasonable doubt. There's absolutely none. Kelly's asking, what about Karen Reed interview with Vanity Fair? Is that smart? No, I don't think any of these interviews are smart. I don't agree with that. I think that's more of a California mentality for AJ. And I know there was something said about that Karen would have cheered for OJ Simpson's acquittal, even though she thought he was guilty. If knowing how a botched police investigation can put you through the ringer, I don't think that should come out in her trial. But I think it's really bizarre that you start talking about OJ Simpson, somebody that most people believe is guilty, and he was found guilty of a civil trial, or the burden of proof is even less. So, yeah, that's not smart at all to do that. I just don't agree with it. But it is what it is, and whether it comes in or not, still not tied directly to whether she did or not. But people can see it. People can start wondering. I was like, why would you make a comment like that? Is it like you're sympathetic or something to somebody that actually did it, but you're innocent, so there's sort of a disconnect there. I just don't get it, and I have not seen it myself. I just heard about it. So in any event, Clayton John, you're asking, could I ever, in a clear conscience, pursue a murder charge knowing Trooper Paul doesn't even know the weight of the vehicle? I mean, there's so much Trooper Paul doesn't know. I mean, no prosecutor should be taking this kind of ash and trash to trial for second-degree murder, especially. So it's if you're going to take a trial, make sure you get a fair trial. But they don't care about a fair trial there. Morrissey's team doesn't care about a fair trial. That's exactly why they hired somebody outside. Nobody inside that DA's office would want to touch this thing. But if they pay enough money and the guy's going to probably get some kickbacks, some awesome kickbacks, all he has to do is this one trial and he's going to get huge paybacks through some kind of appointments, I suspect. Rainy Day Girl says 20 texts deleted and Jen says not her. I mean, who believes that? Text messages just suddenly get deleted on their own and she didn't do it. I would really hammer that. Oh, is that happen? You can cross-examine a witness like that any number of ways by asking, "Oh, really? How often does it happen? Is your phone the only one that happens that way all the time?" And things of that nature. And just sort of do it in a mocking tone where you're really making this witness doubt what they're saying. Because if you take a witness that's lying and act like what they're saying is credible, you're just trying to poke holes at them, then their witness is sort of emboldened to keep lying. But if you call them out on stuff and basically mock them in a way, in a professional way, you're mocking them, then that can start to rattle them and make them really, really on edge, and they start getting nervous about their lies, and they start really feeling like the jury's seeing them for what it is that they're lying. So, yeah, that's one of the things I tell folks that I help in trials. Do not always give the witness the credibility and respect that they're owed. If there's a way you can do it professionally to make it look like you're mocking what they're saying, like it's so ridiculous and they got busted so bad in lying, use that kind of uh, body language and tone and your voice inflections and all that. Use that to your advantage. And through zinger questions, this really shows how ridiculous their story is. So, anyway, with that, I'm going to go ahead and wrap it up here tonight. So, thanks for supporting justice and there for Karen Reed and her team. It's going to be really hard to watch this trial. It really is. It's not going to be the kind of normal trial you see where you see a fair presentation by the prosecution, fair questioning by the defense, and then they argue and it goes to the jury, and then you come back with a verdict. Here you got it's a hide the ball game, hide the truth from the jury. You got the judge putting a lot of weight on the scale, favoring the prosecution at every turn she can. So it's just very much not the kind of thing I'm looking forward to, but I'm looking also forward to seeing true justice happen in the end. And so we gotta believe that will happen. So anyway, with all that, y'all have a good rest of the weekend, and maybe I'll see you back here Sunday night.